This will be at 225 words per minute from video 9. If you'd like to go to that video, State of Wisconsin versus Steven Avery, video 9, it's much slower there, but this drill is going to be at 250 words per minute. Ready, brave souls? Let's begin. The judge has told you that there is 4 charges. I'm very, very briefly going to talk about those 4 because I don't want to reiterate what the judge did, but there are 4 separate charges that the defendant is charged with. First degree intentional homicide, mutilation of a corpse, felony in possession of a firearm, and false imprisonment. Now, the judge instructed you in my job today in opening statement. Again, this isn't evidence, but it is to help you. It is the cover, if you will. It's the roadmap. It's the overview. To talk about the first legal concept that you, as a jury, has to understand, and that's the concept of being called party to the crime. The judge has told you that this can be satisfied either if the defendant committed an offense himself or if the defendant aided and abetted in the offense. Now, the first 2 counts, the homicide and mutilation of a corpse, are charged as a party to the crime, and you will learn at the conclusion of the case 6 weeks from now. If you fast forward 6 weeks from now, the jury instructions will tell you if the defendant committed any of these elements himself, or if the defendant aided and abetted another in the commission of those offenses, that you should find him guilty. Now, I can't stand up here and predict what the defense is going to bring into this case, what cross-examination they may encounter, or if they even choose to present any kind of evidence, nor should I. That isn't my job. My job is to present our case, to present the physical evidence that we have developed, to present the witnesses that we have developed to prove our case. But just remember this concept when it comes time to deciding whether or not the defendant is guilty. The judge has told you something called the element of offense. The state has the burden of proof here. The defense has absolutely no burden to prove the case beyond a reasonable doubt. The judge explained to you already that means beyond a reasonable doubt, for which a reason can be given considering all of the elements. Let me tell you what it's not, though. What it is not, though. Proof is not beyond all doubt. It's not 100%. And when we're dealing with the human and justice system, you can't expect beyond all doubt or beyond a shadow of a doubt or comments we sometimes have heard about that. It's beyond a reasonable doubt for which a reason can be given, and I'm standing before you, members of the jury, telling you that I accept this burden. I will prove this case beyond a reasonable doubt, but we didn't want you going into this case expecting 100% or beyond all doubt, because there are human factors and dynamics that go into these cases. Each case, the judge told you, has elements of those offenses. We're going to go through those in just a minute, but also each one of those 4 charges should be considered separately. You cannot group them together and decide if he is guilty on all 4 or none. Each of the 4 counts are to be considered separately, and in fact, there is separate evidence for all 4 of those counts. And finally, the defendant is presumed innocent. As Mr. Avery sits before you today, because you have not heard any evidence in this case, he is presumed by you to be innocent. However, and this is a big however, that presumption disappears at the very moment when the evidence in this case satisfies you beyond a reasonable doubt that he is guilty of that offense. That presumption disappears at the very moment that the evidence proves that he is guilty. Count 1, the judge instructed you, has 2 counts, and why I'm telling you this and why I'm showing you this on screen or on a PowerPoint presentation is because there are serious crimes. In fact, the most serious crimes in the state of Wisconsin. The legal concepts aren't that complex. We're talking about 2 things that we have to prove caused the death of somebody and did it intentionally. Nothing magic about that, nothing complex about that, and all of you should be able to understand that. The same thing with mutilation of a corpse, just 2 elements. That he murdered mutilated, of course, and that he did so to conceal a crime that had been committed. You will hear evidence in this case about what the crime was that he was trying to conceal. The crime, as you may already have guessed, is the first-degree intentional homicide. Mr. Avery is also charged with felony in possession of a firearm. Again, 2 elements: the felony in possession of a firearm. That seems obvious. And number 2, that sometime before November 2005, he had been convicted of a felony. Now, the judge has told you that the second element is stipulated. Stipulation means the facts that are agreed by the parties that you can take that as already having been proved beyond a reasonable doubt that Mr. Avery has that felony conviction. And so it's just the first element of the offense that the state has to prove. Do you all understand that? All right, now, false imprisonment has 5 separate elements to the offense. The 5 elements are that he confined, restrained. Note, that's in the disjunctive. He either confined, restrained Teresa Halbach intentionally without her consent. He knew he didn't have the authority, and he knew he didn't have the authority to confine, restrain Miss Halbach. All right, enough of the civics lesson. Let's talk about what the evidence is going to show on Monday, October the 31st, 2005, at approximately 2:45. The state intends to prove that the defendant restrained, murdered, and mutilated 25-year-old photographer Teresa Halbach. We're going to prove to you what happened. We're going to prove to you who committed this crime. We're going to prove to you where it happened. We're going to prove to you specifically that it happened, and those will prove all the elements of the offense. What we're not going to prove to you, what the judge has already told you, we don't have to, and in fact can't prove to you, is why. We can't prove the why in this case, on a case like this. That's called motive. The reason behind the killing, what was in Mr. Avery's mind when deciding to kill this person, this lovely young woman. I'm going to introduce to you somebody, this remarkable young woman who was 25 years of age. She was single. She was a freelance photographer. She had her own photography business that was, although in its infancy, was doing quite well. And I will remind you several times during this opening statement and throughout the trial, I will remind you that we're talking about a real person here, talking about somebody's daughter, somebody's sister, and a lot of people's friend. Teresa Halbach had her whole life in front of her. And the evidence is going to show that on Halloween 2005, that all ended. That all ended at the hands of the defendant, Steven Avery. And that was 250. Good luck and happy practicing.